instructed me, especially to
What?
Not only Advocate General has instructed me to have to be for my lord. This matter, item number 1.
Argue, sir.
Yesterday, my lord, it was entrusted to me. Due to my personal difficulty, my lord, I was out of Cuttack, my lord. I could not get it. I pray short adjournment, my lord. Only today, I very accommodated.
Directors to file an affidavit relating to eviction from the government land.
True, sir.
I pray for one adjournment filing affidavit, because I have received the affidavit. In fact, what there is some mistakes, I cannot file it. And now field inquiry we have conducted, and shockingly, once fact came to the notice, the present petitioner has encroached upon 2 acres of land in the same village.
No, on the last occasion, it was said that the private opposite parties are still occupying the government land. And they have shown that what is the area. Then you said that, yes, the proceeding was initiated against the private opposite party. Order has been passed for removal, including the penalty imposed upon them. Not only the position has been taken, but the penalty has also been realized from those persons. So we wanted that on the oral prayer, we should not proceed. We wanted you to just bring this facts by way of an affidavit, so that we can dispose of, taking into account your statement to be true. Thereafter, let them, if they think that this is a wrong affidavit, then they will take an appropriate steps. But you are not giving an affidavit.
In that affidavit, but I am not able to file it because there is many defects in that body of the affidavit. It came from Baleswar.
You are not doctor.
No, it came from Baleswar.
That is the whole problem.
That is what my lord is impressing upon since long, that once the brief is entrusted to you, you should be well versed with what transpired in court. So that day itself we would have disposed of it. But
any other day.
Mr. Tripathi, the learned is
Item number 3, last occasion, I took time to take instruction. I received the instruction from the deputy instructed that they didn't have any role to play. With number 4 is concerned, resettlement, they understood that we are not coming under the purview of this proceeding of the issue, so our name will be deleted. After examining the record, I found that they made a party to the principal bench, Central Tribunal, Delhi, number 1. You should not be a party to this case, even though what judgment then is dealt with the jurisdiction of the Delhi High Court. Second point is that they made a party to the Secretary Defense, they have a limited rule, but real party to whom is required to be implemented, there is a welfare society, is a separate body, separate ministerial department. So he is not meant a party to this department. So I took up the matter to them. let my friend, if he wants, then produce, otherwise I will file another affidavit on behalf of the ministry that this department is welfare taking care about this. I've gone through it.
May submit your Lordships, the petitioner is deprived of the non-inclusion of the DOPT policy under Annexure 4, page 86, Lordship will kindly peruse.
So now DOPT policy is issued by whom?
By Department of Personnel and Training,
Have you pleaded that department as a party?
the opposite party number 1,
One. So
Union of India to Secretary DOPT.
no. DOPT itself has to be made a party. Is a I think the statutory body, DOPT.
No, Lordship.
It's a department.
It's a department.
That's what I'm saying.
The Department of Personal, whatever the training and all, everything. So it is a separate department which is there. It's a body. Will you not make them a party here?
Department of Ex-Servicemen
But
Welfare.
what in a-
Body.
Union of India,
Correct.
Secretary.
I think opposite party number 1 has not been made a Manish. The nomenclature should have been different. But you can
Department
take up this
of
matter.
Party, yes.
You can take up this matter.
But the department has given instruction to me by issuing an office memorandum that this matter will be dealt with by the welfare. That is under the Ministry of Defence, but the different secretary, different department, different organization. They will dealt to they will
That
dealt
is
with the
opposite party
matter. He is
number?
not a party to this case.
4 is the Director General of Resettlement.
They said that we don't have rule. Actually, I examined the records. That's why I'm suggesting the secretary welfare. There is a different department. There is completely the arms tribunal, arms officials, army, navy, all these from the government of India has put up a separate ministry, separate department, that is welfare department, defense welfare. They should implement. There is a different secretary, just like a finance secretary, education secretary. There is a different secretary sitting over the matter, and they have to do it.
Lordship, they have no role in this present matter.
But here his grievance is that there is a DOPT has issued a particular policy and this policy is not implemented.
By the concerned department. By the concerned department, that is welfare, not by defense ministry also. So that regard, they have issued a memorandum. I can file a memo, otherwise I ask them to file affidavit in this.
Lordships, DOPT issued a memorandum, then under Annexure 6, DOPT again issued 2010 guidelines incorporating those policies in a different way that none of the ministries are unable to incorporate the particular thing in their respective recruitment rule. Now the position is none of the ex-servicemen is being re-employed in any of the ministries or any of the departments because of this 2010 guidelines issued by DOPT only. We have challenged that guidelines.
So DOPT is answerable. He is really impinging upon that particular the guidelines.
Yes.
So guidelines is issued by a DOPT. So in that event, it is a DOPT who has to justify these guidelines.
Well, the law, DUPT.
Lordships, I'm requiring it 3 days. I'm secretary, Lordships, it's a prestigious organization.
To file
I'm not being allowed to join neither any, we 3 were selected. I was selected, Lordships, in ISRO, that is directly under Prime Minister's office. Because of this policy, I am not being issued any appointment letter, where the other 2 persons are being issued the appointment letter. In 3 days, I will be rendered jobless. Lordships, you kindly peruse my selection letter.
My lord, UPSC has been made party in this case, but we had no role, my lord.
Just a minute, sir.
Annexure 4 is what? Yes, sir. By DOPT.
Or DOPT itself.
DOPT itself.
Now suppose if you are deposited there, then will your abolition gets selected?
Your Lordship, that is the point. Annexure 4 says it's basically a re-employment for servicemen, and any of the serving personnel at the last year of the services, they will be deputed till they are retiring. After that, they can continue as a re-employment person. Lordship, may kindly peruse para 2 of Annexure 4, page 86.
Column 11.
Column 11, column 10 and 11.
86. 1986.
1986.
That's not been never amended thereafter.
No, Your Lordship. That is not been.
Are you sure?
Yes, Your Lordship. Lordship, we have challenged the CAT vacancy circular. There, in some of the posts, they have incorporated the same thing, and in some of the posts, they have not incorporated.
The armed forces personnel do to.
For sorting out all these issues, there is a separate ministry who is holding this end. That's why.
Please,
Oh, sorry, man. Sorry.
whatever is 86, page 86.
Yes, I have
Page
it.
86, that paragraph, let us see.
There is a policy for the.
Lordship, that is, Annexure 6, page 120 is the relevant portion. That is the guidelines for framing recruitment rules. This 86 memorandum says, Your Lordship, that in each of the recruitment rules, this column, in column 10 and 11, in method of recruitment, re-employment will be there, and in
Up to
column
what?
11, mode of
Up to
selection.
what age?
Lordship, that is still the superannuation only.
So your superannuation when it comes, then what more?
Lordship,
So even if you are you are posted there as per the selection, you have to retire on a date of attaining superannuation.
now I'm 44. I'll be continuing that till 60 because fundamental rule does not. It's not applicable to defense personnel.
On 18 year 1986, thereafter many members of memorandum.
Where is that? That is what he is saying, that till date it has not
He
been
is saying
touched.
so, but
But DOPT has not instructed you that that has undergone any
DOPT
change.
is instructed that the Ministry of Welfare is the concerned ministry who dealt with all the issues.
Sir, you see, but he is saying that since 1996, since this amendment has
Not
come
in-
by DOPT, DOPT must have some answer that it has undergone, if at all, any amendment thereafter.
May I pray on?
Lordship, may kindly
Because
peruse-
that's-
How can welfare department say DOPT has amended or not? It is the DOPT who will say that we have amended or not.
What I am praying, Lordship may observe it and give another date when you
He will be retiring, sir, within 3 days.
Well, within 3 days, there is a no issue to appoint anybody or discharge anybody. It is a
No, he
policy
says
decision should be
he
taken.
has given this, that he has already been selected. His name is appearing in the column number 3, last.
Lordship, I was earlier
That
selected also in a different
Designation
department.
is there, the center organization is there, then the penal position is number 3. You have issued the letter to first two. They have issued.
Yes, sir.
And how many vacancies were there?
4 vacancies. Lordship,
4.
it is written in the.
So why not 3? Why he should be deprived? At the top. Advertisement for filling up 4 posts.
Well, may I pray, my land may not possible to file affidavit, but by way of memo, let them file. Maybe after tomorrow it may take it, tomorrow I will take instruction in this region.
So he has said that yes, his
I
name
thought
appears
the
out
document
of
is
4,
not- Yes.
3 persons, then you should appoint him.
Yes. If possible, file affidavit, otherwise can memo, by way of memo, they can file. Immediately I can took up the.
Though I am not very much in favor of memo exercise,
Only that.
because it does not become a part of the record
Record,
unless it
yes.
is supported by an affidavit.
It's appropriate affidavit, they will.
But
file.
sometimes when he relies upon, then in that event, because this was filed much earlier and this is the subsequent one, 12th December,
12 December.
12 December.
and you have filed earlier. At least first order is of July, so much prior. So it's a subsequent there too. So why are you not issuing?
Well, it is again, it is coming another department.
No, this is the Indian National Space Promotion and Authorization Center.
There is another, again, it is another department.
Both DOPT and InSpace are under PM only.
It's not like.
So they say that the final, these are the candidates who come in the merit, and he's number 3. There were 4 vacancies which was advertised.
So that's why I'm not saying they have to 2 more, let's keep it. So I'll send it to, just now I received from the court itself.
So what this amendment suggests is such persons would be given deputation up to the date on which they are due to release from the armed forces.
But according to what previous public and
Thereafter may
then.
be continued on reopening, re-employment. This is what he is asking at.
Well, my reappointment, all this is concerned. Last occasion, my friend also filed 4-5 cases. One case is disposed by Justice Talpatra and my lord by Ruthi. And that case, they have observed that different amendment divisions came into force. So this department not a party. Still then I assured to the court that I will take up the matter of the welfare secretary as well as the space secretary.
Kindly give the address of that welfare department so that.
Yes, I can be. Secretary welfare, I think.
Let him give that.
Yes, it's probably already
That is Secretary Department of Ex-Servicemen Welfare, Ministry of Defence.
That is under MOD only.
South block. Yes.
Functions under
Secretary,
Ministry of-
2 secretaries are sitting. One is Secretary Defence, another is Secretary Welfare. It's a very big department.
All are under you.
Lordship, Directorate General Resettlement is functioning under DSW, that is opposite party number 4. Your Lordship may kindly peruse. DSW MOD, I have already made the party. Department of Ex-Servicemen Welfare.
Take this instruction because it is a subsequent
Yes, yes.
event to
They have
them.
2 more lots. We keep because
We are keeping day after tomorrow
Yes.
because he is going to retire.
definitely.
And then it says that we will say the notional
Yes.
retrospective effect
Yes. I'll definitely.
or on the day.
Oh, this is DSW is welfare department.
Yes.
Your Lordship.
It's a different ministry.
It is opposite there, opposite party number 4.
See, the resettlement is different. And the department is different.
There are 2 directorates under DSW.
Our attention is drawn to a subsequent event.
Item number 4.
There are some mistakes I found in my petition matter. There is also permit me, no mistake. I can tell it. Amendment is. Deliberate and file a better place. Whatever is your, you have to take a decision, whatever you think. Everywhere.
Memo.
The
Item 5.
Oh, who can live there?
So my lords, the inquiry was conducted, the inspection was conducted on Saturday as directed by this honorable court. And in that. I've also received additional instructions if I may share with them. That's the opposite side, opposite private parties, opposite side, 6. They are staying on the adjacent land.
Is what you say, that there may be some portion which is encroached. So we wanted to make an inquiry and say how much is the portion which is encroached and whether you have to chisel it out.
There's also the toilet facility and one cabin on the border of the
Verified,
information.
examined, Sarjamin.
Yes, Minister.
Oh, she was appointed.
Yes.
Oh, where is your report?
Maybe I
Why?
I'm preparing a detailed report on it, my lordship. Attached
When you went there?
on Saturday, my lordship.
So you had a Sunday and a Monday.
My lordship,
Adapt there, when you are entrusted with such a responsible job. I never heard of that the special officer could not prepare the report within 2 days. It is immediately prepared within a day or two.
Mr. Dalai, you have not guided them.
Brother-in-law,
Achha.
cardiac arrest, that's why
Oh.
he was busy in hospital, lordship, so today morning he.
Tomorrow.
Tomorrow, lordship.
What is your, otherwise, just tell me, what is your impression?
my lordship, there are, on presence of the Amina, they was giving the physical features of that land. And I came to know that including the visit party number 5 and 6, there are 3 other persons are also there who was encroached the same cremation ground from shop.
Substantially or a portion?
A big portion, my lordship.
The demarcation, the viceroy is also directing for demarcation of that area so that can determine how much area is encroached by the cabin and the.
You have that, you have that.
Today the order
information.
will be given for the demarcation.
That instruction you have.
Yes, I just shared it with them.
Okay. You come tomorrow, let us see. And you do the exercise. Tomorrow. This matter is a small matter. She will file a report
Item number 6.
at the top.
I know in the last week. It is for them to verify and.
Again, the same thing, Gochar.
Yes, sir.
So,
Now, Millet, actually, the representation which is annexed to the requisition, Millet, that was not submitted to the collector. And now I have received instruction, Millet, after communication of the requisition, Millet. We have inquired and we have found that 51 numbers.
this was never tendered to the collector.
But after communication.
Sir, show us that you have tendered it to the collector.
Millet, in the meantime.
Wait. I understand. Shall show us that you have.
It is
14/10/2024.
Yes, 14/10 is the date. Where is the receipt? Where is they must have given you a receipt by putting a seal or a signature in the receiving section? Show us.
It is through, the reference was given through post, my lord. You're also with annexure number 2, page number 19.
Yes.
Receipt is there.
No, the
No.
postal dispatch.
Postal dispatch.
That shows that it has been dispatched.
It has been dispatched.
But these documents,
Now can you also the receipt, it is shown that it has been sent to the collector, medium Jajpur. Once he has dispatched by post, then the assumption is that if it is correctly addressed, prepaid, then it has reached to the address. If your department is not so vigilant, they cannot be penalized.
No, in the meantime, they have made the field inquiry and it is revealed that 51 persons were encroaching upon the government land. After receiving the copy of the writ petitions, we have started enforcement proceedings against all.
Demarcation procedure continues. Yesterday, what is the- They have conducted the demarcation.
Demarcation is already
They have-
conducted yesterday.
they have been considering your representative and taken.
Encroachment case has already been initiated, so it will be brought to the notice of this.
Demarcation is also conducted yesterday.
Despite the
This one is against surface and the video. Because of the
Watch
and the video by the
Video.
videos, yes. I think it is just regarding lower quality of work. Usually the government has sanctioned huge amount of money. That has not been properly applied.
how you can assess is the
In this regard-
have you got those structures?
the last
to
occasion,
be-
Your Lordship.
to be assessed by a expert.
On the last occasion, Your Lordship raised that point. And in this regard, a representation was made. And the opposite party number 2 Vigilance Department, the director has sent a letter to the collector to inquire into the matter. And the collector again said to the video which is concerned with the allegation to inquire into the matter. So my prayer is, except that video, any other officer.
So why is there, he will take care of the
Annexure 4 time. 4 and
but
5.
your what you are submitting is not your prayer.
4 and 5.
Sir, what you are submitting today is not your prayer. Come to your prayer portion, paragraph piece 30.
Yes. May be directed to take appropriate action on the representation dated and at the petition on Annexure 3 series, conducting personal inquiry into the allegation made in the representation in obedience to the letter number so of the government, Annexure 4, within a stipulated period.
So that has already been done. Now you are converting, or I would say, digressing your submission. That how can they give it to the video to make an inquiry and submit a report?
Annexure 5 can be.
But that is not your concern. Your concern is that it should act in terms of those
In
letters.
terms of my,
Though,
yes,
they have done it. You have flagged an issue, they have made an inquiry, they have already conducted.
no
an
inquiry was made.
The letter is given,
No,
you submit a report,
no,
you say,
no inquiry was made.
It has been done now, my lords. Thereafter, a committee had been set up, my lords, and the factual report is prepared by the committee, which will be submitted to, it was completed recently, my lord, because the allegation pertains from the work of 2021 till 2024, my lords. So it took some time to take out all the records. Now that has been completed, my lords, and that report will be submitted
21 to 24 records.
because there are allegations.
Time is consumed to collate the records.
To collate the record to check at the site also, my lord, because
And what you will do with 86, 87 construction?
it was only forwarded in July 2025. Thereafter, the committee was set up in December 2025, my lords. And thereafter, now the report is prepared. That's what my instructions are there. And that report will be submitted to the collector today, my lords. And thereafter, the collector will take appropriate actions, my lords. If I may hand over this one.
If that is the present position, on that line, application be postponed.
However, my lords, that portion is not mentioned in the instruction that the report will be submitted to the collector, my lords. That
It's in your over.
constituted by the BDO, my lords, as per instructions, my lords. My lords, here.
I have not said that.
The new BDO joined this year, my lord, and the allegation for.
Item number 8.
Yes. Yes.
Yes, this is a matter, Millard, where the entire land is earmarked in the Khatiyan as a Gochar land. What happens in this matter, Millard? Only one road, one pathway is there, Millard, over the Gochar land. Previously, that was a earthen road, Millard. That was a Kocha road, Millard, previously. Kocha road. Earthen road. Now, Millard, the government has developed it
As a full metallic rock.
PC road. Yes, Millard, metallic road. Now, the sole allegation is that, Millard, without reserving, de-reserving the land, how this road is constructed. I have obtained instruction from the Tahsildar. It is already constructed. Now they are proposing to the government for de-reservation.
That is to be done. And the road is for the benefit of the public at large. So a small portion has already been used for that purpose. The de-reservation is simply a process.
Yes.
There is no difference.
This should be immediate delegation, after that they should.
Sir, and sometimes it so requires, then in that event, one has to be very reasonable. Because it is a public at large who will be benefited. Anyhow, that's to that planning. And it was already a mud road, which was there. Yeah, initiative procedure.
Yes.
Should we keep it or dispose?
That's my disposal.
Dispose.
Item 9, I'll file a additional affidavit regarding illegally done by the audio. I have obtained some information RTI. Yesterday I got the information. I'll file within 2 weeks. I have instructed to the physicians to come to me and I have filed affidavit. Let me give it 2 weeks time. Item 9.
Prayer 2 weeks.
Item 10. Yes. Item number 10.
Last official, 22nd December, the government has filed an affidavit. And this is the matter where there is a construction, and I have breach of rule. That is protected areas, my lord, ancient monuments reservation rule, item 15. After your lordship called for them the affidavit, there was a committee and committee inspected the space and stated that it is within that reserve area, protected area, monumental. But still then, my instruction is the construction is going on. This is the affidavit. They have not filed any affidavit, my lord.
But there is no restriction in the statute, Millard, regarding the why a library cannot be built in the adjoining plot. It is not on the plot where the monument is. It is on another. And Millards, insofar as that encroachment, Millard, encroachment cases have been initiated. There are 14 number of encroachers. Against all of them, encroachment cases have been initiated. And on 7/1/2026, Millard, eviction notices have also been issued.
Oh. So it has already been done.
Yes,
Something is written in, yeah, please take care of that. We are, yes, disposed of, your grievance is already redressed. They have already initiated a proceeding, that is what you wanted.
My lord, the proceeding has been initiated, but no action has been taken.
What they will say, proceeding, they have to follow the rule of law.
My lord.
Yes, so they will take a rule of law and within a reasonable time, you just expedite. Yes, disposed of.
Okay.
Please speak to 7th February, Millard, for eviction.
Already.
Already.
Many time I will go on repeating it because of that. Disposing of, yes, in the same light which I have done today. Not very lengthy order.
Disposal.
Yes.
Item 14.
Give your name.
Lord, I am for the petitioners. On the last occasion, the Council for the State sought adjournment for obtaining instruction.
Yes. Have you installed those water pipelines for drinking water? So they have already taken steps. They say there is already a mega piped water project they have undertaken. And they wanted a 6 months time to provide.
My lord.
It is there, pipeline, but the scanty supply is in short. Everybody is taking from a tube well, which is the government has already set up in the village. They have taken care of your grievance and they will definitely do it.
My lords.
Yes. The instant
lordships.
That's a plan which is situated nearby NH16 under Khordha district, my lord. Since long, some local mafias, along with money demand, were operating lateral stores and morams.
That is not a case here. You have sought
I'm
for
challenging-
cancellation of a tender call notice
My lord,
dated 12/9/2025.
my lord.
It is not a case of an illegal mining activities or a quarry activities having been undertaken there.
My lord, I am challenging the tender call notice. my lord.
Correct. So why, and on what ground you can challenge the tender call
Yes,
notice?
because of,
And who are you?
I'm the local inhabitants, public spirited person. I'm challenging because of that land was reserved by the government authority by making
For,
fence boundary wall.
for?
The public purpose, for development, for establishment of, though I have not filed any documents, but basing upon one writ application, another local inhabitant filed before this honorable court, that is WTC number 20489 of 2010.
Yes.
That land by the local administration make iron fence walls, and that land was reserved for the for very, very valuable land. Now that land is going to exacerbate the lateral stones and moram in their locality, which cannot be used for the public purpose. If
Why?
that land is very.
Is the natural resources
my
is
lord-
the asset of the government
Status
or
of the
the.
land, my lord, Puratana Patito. Status of the land, my lord, Puratana Patito. A lateral stone, some land, lateral stone under the, but that land is.
That is one thing, sir. The superficial layer of a land that definitely belongs to a particular individual or particular person or for some particular purposes. But if the geological survey says that it has some minerals beneath that layer, superficial layer,
Perhaps, my lord,
then the natural resources, can you stand in the way of exploration thereof? There is a law which regulates such explorations.
petitioners along with local villagers are making objection and making grievance.
Where is a law which says that
But,
natural resources cannot be utilized by the government?
but in this case, my lord, without opening any public,
What is the permission? It's a beneath the surface.
by perhaps without.
Under the superficial surface.
So, without obtaining, perhaps without obtaining.
Perhaps don't use word for perhaps unless you are very sure.
In.
Place the facts, not perhaps. Place the facts. Facts means
My lord.
that is based on evidence.
That land.
Place the facts.
That the land is very adjacent to the NH16, my lord.
So maybe, sir, now they have an expertise, they have an experts. They might have undertaken the entire extensive study of the area. And if they have decided to explore this or mine those minerals which are there, in that event,
Authority concerned.
you may have,
Public
but
opinion in their locality. my lord.
where is requirement of the public opinion?
So they are. I love you all watching the PPT is law will place this matter before your last.
What law? Tell me, I'm asking, I'm talking law, I'm not talking facts. I'm talking law.
My lord.
There is a national mining policy which has been adopted, I think, in 2018 or 19. The government has come up with that policy, how to use those mines, what are their motive behind it, and how to ensure the natural resources to be exploited, to be won over in a regulated manner. What is this? Even MMDR Act does not contain any kind of inhibitions or restrictions.
And this is with respect to minor mineral. Minor mineral rules also doesn't.
That is on the basis of MMDR Act, sir. The act is a paramount act of 1956, 57. So you should have a legal right. When you come, then you should show that what is a legally enforceable right. If you cannot show a legally enforceable right, how can you maintain it? Because one fine morning you thought that it is bad, so it is bad. It has to be tested on the anvil of a provision of law. Where is the prohibition that nothing can be done adjacent to the national highway? To us, I do not find anything. Under the National Highway Act, there are many acts under the National Highway. Traffic Act or something, there are other acts. Where is the prohibition? On that stretch, definitely cannot, but adjacent? No, sir. You have to show. This is not an easy way of coming and raising. Mere you are a villager does not mean it's a PIR. Now you have shown the recent judgment. File your ITR. File your income tax return. I think last week the Supreme Court has directed filing of the ITR. File it to show your benefit. What?
Your credentials.
Sir, I tell you, standing at the bar and saying something without any knowledge is a dangerous thing. You are representing the villagers. Are you representing? Very difficult.
Not village.
Whether his income justifies any taxable limits, you don't know. Out of 140 crores people of the country, how much people are filing their returns? Income exceeds that exempted limit. Don't say anything without any knowledge of it. Say.
You
are a very responsible
sole individual. You are sole individual. You have come, not the village.
Yes, what is your instruction?
Here, Ballot, instruction ballot, there are two queries which they have challenged here, they have questioned. And in both the queries, they were put to auction. In respect of one query, the first highest bidder could not take it, could not deposit the performance security. Then it was given to the second leaseholder, a second H2 bidder. H2 bidder also could not submit. So they are now deciding to put the query for further auction. And so far as this.
So cancelling this one, saying that it is now not possible.
It has been cancelled, I think. I'll produce those instructions for you. But on preliminary instructions, and so far as the allegation in the writ petition is that the kisam of the land is Puratan Patit, so it cannot be given in lease for mining purpose.
What is the meaning of this Puratan Patit?
This is a
Puratan, I know, it's a Puratan ancient.
The wasteland under the Government Land Settlement Act. If your lordship may kindly see government land, it says means any wasteland belonging to the government, whether cultivable or not, recorded as house site, Anabadi, Chota Jangal, Puratan Patit, Nutan Patit. But these are wasteland. And under 3, reservation and settlement of the government land, notwithstanding anything to the contrary in any law or any custom, practice or usage having the force of law, government shall not be deemed to be debarred
from exercising all or any of the following powers in respect of the government land. A, to reserve such portion of the land as they deem proper for the purpose of being used as house sites or for any communal or industrial or for any other purpose whatsoever. This is specific under the Government Land Settlement Act. And so far as the minor minerals is concerned, minor mineral does not specify which kind of land be thrown open.
Because nobody knows, it may be.
Nobody knows. And these
What
are
is
all
there
natural
beneath,
resources.
what is there beneath the surface, nobody
Yes.
knows.
So
It's
that-
only the geological survey or whatever. The expert can explore that there, it may contain a mineral. Law is against you, sir.
Keep it next week we'll test.
What next week, for what purposes? You can't say cancel the tender. Now, there are two things. One thing is that so far as this tender is concerned, he has said that two bidders who were found successful, H1 and S2, both have defaulted. And there is no taker of that. So now they wanted to float the new one. So practically this tender has gone in a deep sea. What more? This tender.
Well, this tender, they are referring to two scheduled land properties, my lord. So Lordship may kindly.
No. Regarding this tender, H1, S2 have
This
defaulted.
tender, there are different queries. In this tender, there are different queries. They are only referring to query number 6 and 7. So for a 6, it was given on lease. And 7, there was a default of both on part of it.
6 is already given on lease.
Yes. The new mining officer has joined, so I have asked him to come up with the records and produce everything for this on.
I mean, the next week, let him come. But we want on the play of the petitioner.
One is for Moram, another is for
Yes, lateral.
laterals.
Earlier also 2 times the tender was put and cancelled.
So if there is no taker, then how can you enforce if nobody wants to take it? So it is better that let them do it themselves.
Item 16.
Momentary instruction. This is the case of enforcement of Gosford land, Miller. Process has already been activated. Lordship, kindly turn to page 22, Miller. The Tahsildar passed an order on 13 February 2025, fixing a date to 19th March 2025 for eviction, Miller.
CS suit is pending.
Yes, Miller. Thereafter they file a decision coming to that. Now, Miller, on 19th 2025, Miller, it was brought to the notice of the Tahsildar that civil suit is filed and one interim application under order 5921 and
Has any order is passed, injunction?
Now, Miller, it is subsequently came to the notice of the Tahsildar that Miller that on 10/4/2025, in the interim injunction application has been dismissed, Miller.
Dismiss.
Now, Miller, we are proceeding further. It could not be brought to the notice of the Tahsildar. Now it came to
10/4.
10/4/2025.
So what you are doing? Nearly 10 months or so.
No, they are party. Tahsildar is party with the.
Tahsildar is party in civil suit. For
Civil suit.
Yes.
How could he not know
Miller,
regarding the
in the interim
status?
application, interim application, Miller, Tahsildar has not made a party.
How can you? What are you talking about?
No, maybe.
No.
Status quo.
No. In a civil suit, if a party is arraigned as defendant, how can he not be a party in an interlocutory application? I think I have learned the wrong civil law.
No, Miller. That actually what happened, Miller.
You may ask for an injunction against any of the defendant, but you have to arraign everybody as a party there in an interlocutory action.
Actually, plenty party did. He only arrayed the collector as party in the interim application, Miller.
How can it be unknown in civil law?
That was
cannot say. It is for the plaintiff to see.
Now let us come to the knowledge, Miller. We are proceeding.
The plaintiff is there here.
As per the
That plaintiff is there, that party here?
no, my lord,
No.
no. Only it made a party.
It is your petition. I am asking you.
My lord, sir.
You are aware that CS case was pending.
Yes, there are.
You know.
No.
Then plaintiff, where is the plaintiff here?
Plaintiff is there.
Again the same question.
In this case, they are the opposite party.
That is what I am saying.
They are opposite parties.
In this.
In this.
Have you implemented them a party? Have you arranged them or included him as a party,
Yes.
as opposite party?
Yes, ma'am. Yes,
Three opposite parties are,
Yes,
sir,
ma'am.
3 opposite parties are there.
There, yes, ma'am.
They are the plaintiff.
They are the plaintiff in this.
Ah.
Yes.
Then it's 5, 6, 7.
5, 6, 7.
You should have described their plaintiffs there. Anyway,
My lord, as per the instruction of the
Let
current
the
client, my
parties be
lord.
go.
and what about this earlier writ petition? Who has filed this writ petition? 28936 of 2025?
One of the villagers.
One of the villagers. Why was that disposed of?
And my lord, it is a file a single bank, that's why they are on single bank not entered in the.
They are not written the date of disposal.
Yes.
On a technical ground, it was rejected.
Yes, my lord. It's not a case for a single judge.
Okay.
That's what they are.
So you give a notice to these persons because we will be passing an order which will affect adversely.
Yes, yes.
Notice on 5, 6, 7.
As per
3
the
weeks.
instruction of the client,
Now you
direction
see
government look at, Tahsildar went to the spot, but remained silent.
Mr. Khare, he has submitted that they are taking now steps because they were ignorant about
Already.
that order.
Yes,
On Friday, Milord, demarcation has been conducted.
Yes, yes.
You continue whatever you want to do it. We wanted to give them a notice because they have been arraigned as a party. So you file the requisites. 3 weeks. This
I'll produce next day.
please start.
Yes, ma'am.
Item 17.
Lordship, can you do it after so that I can convince the Lordship so that Lordship will put more on the ground of maintainability? I have. For all the judgments, Lordship, it take some time, Lordship, let 1 week after I can convince the Lordship. Because
Sure.
sure, so I can convince with something different, Lordship, that
Sure.
matter is.
He was busy with
Because-
his associate's daughter's marriage.
Cooperative society.
No, it's not accounting.
I have Lordship, Lordship judgment, I have Lordship.
I know. That is what is the latest position I just wanted to know.
I have.
I just lost track. So that's why I'm just wanting. I know some judgments says yes, some judgment says no. I just wanted to know. What is the latest position now?
The cooperative society matters. Earlier, cooperative society was part of Part 9B of the Constitution of India. That is all, it was a constitutional rule. Now, by virtue of a judgment passed by the Honorable Supreme Court, the 4th part is deleted from the Constitution. So cooperative society is gone out of the Constitution, but it continues to be a statutory body. If the Lordship will consider from the perspective of the cooperative society as, the Lordship will find there are provisions. If the society.
No, I was aware that cooperative society definitely is genesis can be traced from the statute itself.
Correct.
Cooperative Society Act.
Correct.
Now the question is when this act is an exhaustive provision, contains an exhaustive provisions, it's the self-content provisions, and the remedial measures are also provided therein. Then why these kind of a writ petitions should be entertained? It has to go within the framework of that.
Right.
So that is what I really wanted. So for that reason, because maybe a public element, they are discharging the public functions. One of the principles of understanding the meaning of or a definition of an authority appearing under Article 12 is the discharge of the functions. What are the nature of the functions they discharge? If it is a public element or a public flavor is there, then definitely they can come. But But that has to be seen
Yes,
with
yes.
certain more,
Right.
I would say, conservative look.
Correct. But I will be supporting my learned friend here. I will be appearing for the OP number 4 here in this matter.
Lordship, I am appearing for OP number 3 for the bank. Apart from the Article 12 objection, I have also an objection regards to fact. In WPC 3627 of 2022 on Anand Chandra Mahal, it was decided by this Honorable Court that the MD shall be chosen by the management committee, not by the government. Then the management committee.
What is this? What you are saying?
Tax lordship.
No, what is saying? What
I am saying that in WPC 22754 of 2024, this Honorable Court has put on a stay on the appointment of MD by the management council. No, it is a fact.
You are not aware about. I know. I am all these litigations. Day one. That's my. He is not aware about. In fact, what is the issue here? We are also will relate back to Venumada Tripaঠি's case. What is the issue? One director was there.
Covaranto. You were appearing.
Covaranto. That's the matter. I was rather.
I was part of that.
Venumada Tripathi Covaranto was issued by this Honorable on the exceptional reads. Not saying that the appointment of these and MD was contrary to rules. He has no qualification to continue as
You are citing Banking Regulation Act.
Banking Regulation.
So that was not followed. Appointment was made by the government instead of the.
After his retirement, he was allowed to continue as the managing director of Kasar. So that was allowed. After the writ of Covaranto was issued, again the same person was appointed by the government. Again that was challenged. So this Honorable Court took an exception to that, stayed that order, and an interim measure directed that the registrars are remain in charge of the entry of the bank.
Who?
The Register of Cooperative Society
Okay.
shall be in charge of the bank. That interim order was also there. When the repeal was pending with that interim order, Committee of Management came before this Honorable Court and made a submission that we, as per section 28(1) subsection Roman 8 of the Act, read with section 33A of the Cooperative Society Act. It is the government managing committee of the bank has authority to appoint its CMO, chief executive. But the qualification of a chief executive will be fixed by the Register of Cooperative. That is 33A. So the committee of management wanted liberty to fill up the post. Accordingly, that interim order which was passed, that got modified, permitting the committee of management to go ahead with the process of it.
Okay.
So while that was going on, the writ petition was filed because the MD, who was the registrar who was continuing as in charge, that writ petition, the status quo order, that was disposed. Once this liberty was granted, the status quo with regard to that registrar and MD, the writ petition disposed. The second writ petition disposed. So as a consequence, the status quo got vacated. So the registrar could not have continued as in charge MD of the bank. So that is why the other petition was filed with Mr. Mahal, my learned friend is citing, that direct for a direction to the committee of management to fill up that. So a direction was issued to the committee of management to fill up that. It is at this juncture, at least 10 petitions came up thereafter. The political setup changed. And government started taking action against the committee of management, like disqualification, suspension, all these, and these petitions were filed. Batch of petitions were filed and interim orders have been passed. In one of those matters, one PIL was also filed, seeking a direction to appoint one MD. PIL is also pending here. So in one of those petitions, an interim order has been passed. The suspension has been stayed with a rider that the committee of management shall not take any policy decision, including issue of appointment of the management. So that interim order, by virtue of the judicial order passed by this Honorable Court, all these matters are tagged together, constituting a special bench by my Lord's predecessor, taking my Lord Justice Mahapatra into the bench, because the interim order was passed by in that court. That bench was supposed to take up those matters. It is at this juncture, now the Mr. Dolly's PIL has come. So, but your Lordship need not delve into.
Then in that event, if those matters are intertwined or interconnected, then this matter should also be tagged with that matter.
That should be left.
And if there is already a special bench.
Special bench, concerning my Lord Honorable Chief Justice and Justice Mahapatra. I mean, my lord, the predecessor, his lordship was there.
So it has to be reconstituted.
Yes.
Can you give me those
I'll give all those
numbers?
Is this the order? Is this the order?
Yes.
Single bench,
Yes.
honorable.
That
single
is why
bench
the
has-
bench is constituted, consisting of the Mahapatra.
So all these single bench matters have also been
together,
tagged to the division bench.
all of them tagged together.
Give me the number and
My learned friend will give all those.
with Justice Mahapatra is
Yeah.
absolutely.
So that single bench also merges into that.
No, that is. This PIR has to be tagged with that.
That's very limited. For
Have you given the copy of this?
my learned friend will give all those numbers to you. The registry.
In course of the hearing, it is pointed out by
Single bench matter, that is different.
Let me clear.
So why should we keep?
Both these
Why
matters are
have you-
different.
These are different matters, but the question of law.
Don't mix up, sir.
No,
We get
this.
So those
this mega
matters
apply
which have been
related to-
referred to a special bench, please give those numbers.
These are the numbers.
That's all, nothing more than that.
Right.
Do not want to
Set up. Set up a
call the next part.
Regular set up.
Yes.
We don't confuse,
Related to cooperative.
It, call the next.
Item.
4789 plus 24, that is the
Reading case.
great. Grateful.
Item 18.
Your lordship were permitted me to amend my prayer. Because I have filed an IA amendment prayer and I have also filed a consolidated writ petition. Because lordship go to page 15 of the consolidated writ petition. This is my prayer.
Yes, where is this IA 791? Has it been included? No? This is a proposed amendment.
Proposed amendment is at page 3 of the.
So only the prayer portion you want to substitute. Then how the A and B? It should be AA or BB.
No, this is the schedule. This is proposed amendment at A, B.
Sir, that means these are the prayer, issue a writ of mandamus.
Yeah.
So there is already a prayer A.
Yes.
So are you substituting that prayer A?
No, I have in that original petition, I am not substituting A.
Then what?
This A, B becomes B and C. And C remains B as B.
That should
It
have
does
been your.
not, it does not know how to amendment has to be carried out, sir. Sir, there is already an original prayer which is categorized as A, B, and C.
Yes, sir.
When you are inserting some additional prayer,
Yes.
then it has to be indicated that this prayer A will be prayer AA
But
because the A will remain. Once you say A means you are substituting this prayer A, original prayer A with this prayer A.
no. But in the IA, prayer should be chronologically mentioned. Therefore, I have.
So will you not indicate in the schedule of amendment because the amendment has to be carried out as per the schedule. So there will be two prayer A, there will be two prayer B. You cannot arrange. It's not an addition application where you can rearrange the number of the litigants.
But in the amended prayer, the A is there and this A, B becomes B and C. And also filed the amended prayer will also filed.
Are you aware of Order 6 Rule 17 and Order 6 Rule 18 of the CPC?
Sorry, see, but the writ petition, the schedule.
So CPC does not have any application. If CPC has no application, then res judicata, why the writ courts introduce the concept of res judicata? Because it is appearing from section 11 of the CPC. Why the writ courts are introducing the joinder of the multiple causes of action? Why the writ courts are embracing Order 2, Rule 2 principles that you have not claimed any release in a fullest form? You cannot do it in a subsequent litigations. Why? Why? It's the CPC does not apply.
IA, there has to be, it cannot start from B and C. It has to be chronologically arranged. A and B.
Sir, you do not understand the nuances of the amendment. With deepest of respect and humility in my command, I believe that you have never filed any application for amendment. Whenever you are amending a particular prayer, if a statement is to be included in the form or in the content, then a separate paragraph you have to introduce in the schedule. If you want to introduce this fact after, say, paragraph 10, then you will say that please insert paragraph 10 capital A. If you are amending the reliefs, additional relief you sought for, then after A, you have to say that it should be amended as AA or A1 or whatever. Or you could say that after prayer C, it should be written as D and E.
Part 5 of page 3 of my.
Sir, amendment would be done on the basis of prayer or on the basis of schedule? Tell.
But schedule
This is the schedule you have included in page 3. Schedule of amendment.
Yes.
How you have written?
When I have clarified that in para 5, kindly, I'm reading just a minute, kindly bear. In view of the aforementioned development.
Mr. Right, Mr. Sanjay.
Tender matters have been instrumental only because of the stay order. This municipality is not able to proceed. So we only may take the lead to make a fresh tender. Already since long it has been pending because of the order of the stay. Only your lordship rightly noted on a page 28, this is 15 big clause, that is the restriction, there is a restriction to the blacklisted candidate. So, my lord, only with take permission, and your lordship direct anything, my lord, we are abide by the order of the Supreme Court. Only because of three tender, no, only two tender, there is the two writ petition have been one tender against two writ petition, and another tender, another the writ petition. Three writ petitions are pending, and the stay order is operating, still operating. And
So all these matters are listed today.
yes, ma'am.
So let us hear where the interim order is passed.
Yes.
Let us see what is the who is appearing. Which one is the connected one where the interim order is passed?
All annexed 2C.
In all matters, interim order and mentioned.
Oh, so this 19, the main matter also the interim order is there. So let us see what is the nature of the interim order.
If the lordship status come to a conditional clause, what is the terms of conditions? Such a arbitrary condition should not available in the art lordship. How they have interpreted the blacklisting, so very funny lordship. Right. Clause
No,
15.
in this matter 36703, there is no interim order. Simply recording that there has been writ petitions which are where the interim order are passed and directed the tagging of these matters along with that.
Now the PI, they filed 36
703.
Huh.
Only in that PIL, there is only sanitization and the sweeping
Correct.
and the collection of the parking fees. That
Yeah.
has been already stalled, my lord. That's why the file a receipt PIL. So against the PIL, last occasion we have received also by our submission, the matter listed.
So that is what I am trying, where the interim order is really impeding
Yes,
your progress.
yes.
Let us take those matters.
Yes, yes.
Let us see that the interim order should continue or not to continue.
Yes, yes.
Which matter? At least 36703, no order.
That is
1097, now, the 10917. Let us see. What is this matter? Who is appearing for the petitioner?
I am
Where is-
behalf of the prisoner.
Yes.
Prisoner wants to withdraw that.
10917, want to withdraw.
Yes.
Do you have any objections? Because he has taken a benefit of the interim order. Do you have? No, there are judgments. That's why I'm asking this. Do you have any objection?
No, we have no objection because.
No objection.
Yes,
So we will record so that it goes. Then come to 11138.
That is mine.
Show us that whether the interim order.
So number telephone 10917. Withdraw kari. Mr. Karuna is appearing for Baleswar Municipal. Has not been taken on the Mr. Pradeep Kumar wrote for the petition, filed a memo.
Who has issued the tender? Just one minute. Yes, who has issued the tender?
Executive officer, Baleswar Municipal.
You are municipality representative. Can you impose these conditions because it is contrary to the decision of the Supreme Court? The word ever shows the perpetual civil debt, which is not the law. He may have blacklisted for a limited period,
OPD.
and if the period has gone, then he is entitled to participate.
OPCW code also provides only 3 years.
Panda
So,
infrastructure.
Panda infrastructure, our own judgment subsequently. So how can that
They
has
have
to go?
Permit to retender.
We are washing it.
Deletion of this clause, Lordship.
No.
No, that word.
No, that word ever.
Yes,
Sorry.
that full Lordship. That is totally.
We'll say that it cannot. Now they have to rephrase it.
Yes.
Yes, but.
Now this is 11138. What about 14048?
You put that in terms.
I am appealing to the petition.
Yes, what do you say?
15 different. There are two tenders. Initial tender I participated.
What is the ground of challenge in this tender?
There was a clause in the first tender that experience certificate is required in order to participate.
Yes.
And the private opposite parties, they do not have that experience. So what it did is they floated a fresh tender during the pendency of this tender for the same works.
So they can. That means implied cancellation of this tender. Once they floated a fresh tender, that shows that the implied cancellation of this tender for the same work.
Yes. The experience part they have amended.
So it has to be.
That was giving a better hand to the petitioner.
It is not. What do you say about it?
And we have said only earlier tender, Regis 2000, Regis 25 are already been cancelled.
Oh, I understand.
Yes, a fresh tender has been floated. And
Are you challenging the fresh tender as well?
Yes, ma'am.
Yeah.
Yes.
They have challenged the fresh tender, saying that we have participated in the earlier tender and that has not been cancelled. So
No, that is cancelled. We cannot. But so far as the conditions are concerned,
yes,
have they said that these conditions are
already
contrary to the principles.
Tender fees also, we have filed this counter in this case also.
Yes.
This is tender fees also returned to them, returned to the petitioner.
Oh, that is the earlier tender. He is
Earlier
not
tender.
saying, he is talking about the
Fresh.
further tender, fresh, where you have refurbished that particular eligibility clause
Yes.
and making this cherry picking or cherry picking person to support. This is what they're, that you can't choose a blue-eyed person.
No,
So he says that this is not correct.
that's why we can also make a fresh tender.
Fresh. That's true. That's all. Then what is left? Nothing. So we are coming and dictating.
So that is standard notice 9995 of dated 7/5/2025.
You just, we are coming back, you refer those, the earlier clause of the tender and the another clause that how they have done it.
Yes.
You just edit it. So that is within your rights. There is no difficulty. After all, this is the important thing.
Litigation has been already.
Whatever, you understand.
Don't, yeah.
Let me dictate tomorrow. First matter. All those matters. Record one.
That
Withdraw. Yes, tomorrow itself. Don't worry, it will be tomorrow. But record that. Memo is filed. No objection. Because it has to be done in a separate manner. Can't be done in a common manner. Yes.
Item number 20.
Petitioner pays to withdraw.
Next.
Fine. Any interim order? Other side?
Yes.
Why don't you respond when the matter is called? You are just sitting idle as if impression is created that nobody is there for the opposite party. Yes.
Item number 21.
Item number 21, look at PI matter, your document and the relating to the pollution control certificate. Pollution control certificate, your also has issued direction to the state transport authority to file an affidavit with regard to that. Why they are not issuing pollution certificate unless there is a clearance of previous challenge. And furthermore, they have debarred petrol, issuance of petrol product to the vehicle owners if they don't have the, my lord, pollution certificate.
I am appearing for opinion for that is Indian Oil Corporation. A copy of the writ petition may kindly be served.
You are appearing for?
OP number 4, your lordship, Indian Oil Corporation.
I am for the
Appearing for the first year.
for reliance.
What is Mr. Prabhakar?
And who is for Bharat Petroleum? And Hindustan Petroleum? What about your stand, sir? I think you have issued a notification.
Notification was issued by the Transport Commissioner,
Huh?
number 2.
So are you not representing?
Opinion number 2 is represented by the Standing Council.
Where is he? Earlier he appeared. Earlier he appeared.
Yes, my lord.
Mr. Prabhakar Behera.
Behera.
That affidavit is required to be filed for this.
That is what we wanted. On the last occasion, we ordered.
And so far as the impugned order, where it has been made some precondition to have a PUC check before dispensing the petrol. My lord, regarding that, I am told that further clarification to that impugned order was issued by the authorities on 22/12/2025, where they have said that it will not be insisted.
Okay.
The PUC.
So this is redress.
No, my lord.
This will come on by way of an affidavit by Mr. Behera. Proceed may kindly have. And this has been issued to Indian Oil Corporation, Bharat Petroleum, Hindustan Petroleum, Reliance Industries, Shell India Market. They have said in continuation to the letter which is issued, wherein you are requested to create awareness regarding PUCC and not to prohibit
So
dispensing petrol, diesel.
There are twofold, my lord, grievance of the petitioner. One is for that which has been redressed, my lord, partly. The another part is that for those who are not having the PUC certificate, when they are going to the PUC centers, they are not issuing and insisting unless you clear the previous challenge issued against the vehicle has to be cleared. Thereafter, we will only issue the PUC certificate. That for that reason, your lordship has directed to State Transport Authority to file affidavit to that effect, because the large number of people are suffering, my lord, even many people.
no. I tell you the object is very laudable. Object is very pious. You can't say, because a person who has violated the traffic rules or any offences under the Motor Vehicles Act, if there is a penalty, something is imposed, he cannot go scot-free in that.
But when there is an illegal demand,
Who will decide? I am asking, how do you decide it is a legal demand or illegal demand? Tell me.
Decided by the transport magistrate.
If they have imposed, is there any conditions which have been imposed by the judge before whom the matter is pending? I think it is pending before the JM, judicial magistrate. Not a transport magistrate. It is a JM. I think judicial magistrate.
State transport. And in the every your lordship's
There is no categorization.
My lord, JMLC transport. My lord, a designated officer, the judicial officer is there. JMLC transport.
Transport.
Yes.
What is this new nomenclature? I am not aware of.
It is a
Very unique. Everything I find very unique. Once the challans are not paid within the time frame, then it is mandated under the law to refer the matter to a judicial magistrate's court.
Yes, madam.
It does not say the judicial magistrate transport, judicial magistrate otherwise. It may be a jurisdiction wise it is given.
Yes, madam.
Every GM has the territorial jurisdiction on the basis of the police station.
Yes, madam.
So the challan may be there in different police stations.
No, madam. The traffic
Magistrate is.
One magistrate for this
One
challan cases.
One magistrate.
For challan cases.
Yes, madam. We are having in Cuttack, madam. In Cuttack itself.
Transport.
That is why
It is correct.
Every day.
Spending.
Mr.
Maybe. A public interest litigation, I was seeking for a direction to stop monitoring.
Yes, Madrak. Bhadra. There is a policy decision of the
What,
government.
what has happened to that matter?
That matter, we have, what I,
We have disposed of or it's came?
it is pending. We have
So
taken.
let it appear along with just
Yes,
on that,
yes.
when that matter has been directed?
I'll check it up and pass on this report.
No, not to be tagged, but I just wanted on the same day. So
Same
that
day, yes.
There is another matter related to Bhadra.
Yes, please.
This is the matter with, give the number.
Yes, number, just give the number.
The next.
Miles.
Give a number, so.
Yes, yes.
One after the other.
Now, pay you.
Postal.
Yes. Yes, sir. 28.
28 already, Arjun. On this case. 29. Item 29.
This matter related to the Ratnabandha. Yes. There are three.
So.
Yes. So there are three players.
Minute may please, minute may be permitted to submit virtually. Minute I will request Mr. Das, my learned friend, to hand over the instruction furnished by the chief administrator of the temple, Jagannath temple, that the steps which have been taken in the meantime since the opening of the Ratna Mandap by orders of this honorable court. Minute, may I place it? The entire
There is
sequence of
already a
events.
committee headed by one of the retired judge of this court.
Yes.
Who
Your lordship is correct.
who has to inventorize the entire assets or a Ratna Bhanda.
Lordship is correct. Lordship is correct.
So that has been done.
Justice Vishwanath, that has been done. 1, 2, 3 may place it before your lordship. That
Yes.
instruction is there. I think that printout, Mr. Das.
No. Information on the steps taken for carrying
Yes, that's
out
correct. That's correct.
inventorization of. Yes.
Yes, may I place it, Milord. In order to assess the Jagannath, because this is, inventory is to be done by the committee under the Jagannath temple rules. So the entire mechanism is there, how it is to be done after obtaining the government order, because the government was not opening it in view of the loss of the treasury key. So therefore, this court, the honorable court, directed the government that the inventory would be done, inventorization would be done by the committee, and a retired High Court judge would be supervising that. So accordingly, the state government on 9th of July 2024, Milord, appointed Justice Vishwanath Rath as the chairman of the committee and some other members also. So, Milord, the standard operating procedure was framed by the government, how it is to be done. Then the law department on 13th of July 2024, this is Milord Bhitar Ratna Bhandar, because Bahar Ratna Bhandar is no issue, because on every festive occasion, the jewelry is kept in the Bahar Ratna Bhandar, which is called the outer Ratna Bhandar, they go. Because there are 12 Sunabesas of Lord Sri Jagannath on various occasions throughout the year. So during Rath Yatra, 12 besas, Milord, on 12 occasions. So this inner Bhandar key was missing.
This has already been done. I think both have been
That
done.
has been done.
And
everything
all the
has been done.
Ratna and the jewelries or whatever has been kept in a strong room.
Right. So now, Milord, it is to be, Milord, matched with the last report inventory which was done. I was submitting the other day on the last occasion.
Correct.
In the year
Now it has to be
1978.
collated.
That's correct. So, Milord, that we have written to the Reserve Bank of India, because they have to send these jewelers how to, Milord, take the weight and other things. So, entire thing up to date, Milord, the 10th point.
SOP prepared by the BD subcommittee of the was point number 8, approved by the high
Yes,
level.
yes, yes, I have, yes.
So, it is going on because
So it has submitted to the state government after
Right.
the approval of the
Government.
Gajapati
Yes.
Maharaj and the chairman of the SJTMC.
Yes, Sri Jagannath Temple Management Committee, SJTMC. So now
Yes.
it is to be done. So your lordship may record it. This instruction which was furnished by the
How
chief
long will it
admin
take?
secretary.
How long will it take?
It may take me the last inventory which was done. It took almost 1 year or something like that. I was told because Mr. Senior Biswabhushan Harichandan was the law minister then in 77. Incidentally, his son is the law minister now in 2026 when the inventory is being done. So there, Governor, the then Governor, Bhagwat Dayal Sharma, His Excellency was the chairman of the committee with 9 other members. Now also there are 9 members. We have taken persons from various walks of life. So they are supervising. The repairing work has been done by the ASI, that is over. Archaeological Mr. Padhi is appearing
Everything has been
representing
done.
the
So far
Union
as
government.
the draft SOP has been concerned, it has already been
Now,
given a
yes,
final approval.
Yes.
And I
Right,
think the report, the everything has been done. Now it is before the
Everything has
state government has to approve it. And now these jewelries, as you said,
right.
Then
Right.
So that has to be find out.
They have to be tallied with the.
No, last actually the SOP was there, so it has been approved on 17th of January 2026. Now it has gone to the
Right.
state government. Now inventory has already been done. Everything has been done, found out.
Right.
Now it has to be matched with the
it is-
earlier report. Now there is every possibility of an increase, definitely
Right.
not decrease.
No, increase भी होगा नहीं मिला. Increase will not happen because it is
Or
kept
it is to
intact.
be same. There are two things. Either it has to be same or it has to be increased.
No, increase question doesn't arise, Milord. It may decrease. I do not know what would be the outcome.
Why decrease?
Because decrease भी हो, Milord, decrease would also not happen. If it is
It will
decreased,
not happen. It should not happen.
it should not happen. It should not happen. If it has happened, then it is serious. We'll take
Absolutely. Absolutely. It can only increase
So,
or
Milord, that
remain
was the
same.
apprehension. It has to remain the same with the 1978 report because it has not been opened thereafter. So between 78 to 2026, if at all there is a mismatch, that would be construed very seriously by the government and appropriate measures. Milord, that stage has not yet come. So, Milord, let me just explain. In 1952, I was submitting to your lordship the
That
other
is
day.
what my point.
That's
It is there. So now you have to complete the entire exercise within a time-bound manner. You can't.
Right.
You can't. So we are directing you to do it. If you want, we can give you a 1 month time.
No, 1 month period, it is not possible. It's a very onerous.
So how much time?
So minimum, I have to consult with them because I do not know what would be the time to be consumed for that purpose. But
So
the counting could start.
We are giving you 2 months time to complete it.
No, not complete to start it. It may take 1 year also.
No, starting should be done within 15 days. Completion should
starting
be
should be done within 2 months. Milord, your government has to, Milord, the government will now approve it, the SOP. So after approval, as per the Jagannath temple rule, the inventory process will commence. So once it has commenced, Milord, it has to be done periodically. Every day it cannot be done because festive occasions are there, devotees are coming in great numbers. That should not cause any dislocation for the safe darshan of Lord Jagannath. It is a simultaneous task. So therefore, let them begin within 2 months, your lordship may. हिटलर सेनापति कौन है? हिटलर सेनापति Incidentally, Milad, in a later vein, I was the lawyer for the petitioner in the case where the Honorable High Court directed for inventory. So therefore, I am also equally serious. I was the petitioner's counsel. It is a second PIL. I don't know for what reason, but that is the PIL, Shamir Mohanty versus State of Orissa. So it is all for. So therefore, Milad, the government is very serious rather. It was.
Commission report. It's been 3 years.
It's a dummy petition. Actually,
They are going to.
the judgment is, original judgment is in Samir Mohanty versus State
What
of
is this
Orissa.
Inquiry of
That is-
Commission Act? What is this?
There was the allegation that the key of that document was missing.
That's a,
There was only one key, so it was missing. So the collector found out that there was a duplicate key. They found a duplicate key. There is only one key. So how they will find another key? So there was a commission was constituted. It submitted a report in 2018. It's been 8 years they are sleeping over this matter.
We are directing. Where is that?
They have filed 2 affidavits, my lords.
but the commission report, let me explain that. The commission, in fact, that was during 2018. There we demanded that there should be a commission of inquiry because the key cannot miss, it is to be kept in the treasury. So the government appointed in 2018 a commission under the
No.
High
The
Court.
commission was appointed. The commission has submitted the report.
Submitted a report, they did not open it for
that
7
is
years.
in 2018, the report was
That is
submitted.
absolutely
Now,
correct.
now thereafter, now
We
7
will
years
place
has
it, Milord.
passed.
We
What
will
has
place
been
it.
done?
Milord, we will place it in the house. In fact, that
So we are
commission
directing, you are having a session when?
session, this budget session will commence, I think, date I do not know, in February, sometime, I think 20th
So
February.
in a next session, then you will have
In
to
the
place
next
it into the
That's-
house, on the
that's-
floor of the house.
Your Lordship may direct.
Yes.
That will be no issue. There is no issue on that. So that is no issue on that. We are keen to place it in the
Yes,
house.
definitely.
We'll do that. So number 2, this inventorization process, Milord, it's a very lengthy process.
We'll just go through the entire record and the orders. This will be a bit extensive orders will pass.
Commission
We will
issue by-
direct, first thing is that we will direct this particular, the report which is submitted by the inquiry, on the basis of the inquiry, that has to be in a coming session, has to be placed and a decision has to be taken, subject to definitely. There is no ruckus or an impasse being created. Secondly is that so far as this SOP is concerned, we will give a timeline within which the SOP, that a decision has to be taken thereupon. And then the process has to be, if they accept, then the process has to be done. And thereafter, we'll fix the timeline.
Your Lordship may give some
Tentatively.
this inventory.
Tentatively.
Yes, ma'am.
Milord, 2 issues are different. One is the commission of inquiry, which was, Milord, under the chairmanship of retired Justice Raghuvar Das. He submitted a report, I think within 3 months or 6 months.
Report has to be placed in the floor of the.
That has to
house.
be.
That is what we
keen to place
wanted,
it.
that you either you accept or take a decision or to do what, something has to be done. 7 years, it cannot be done in medio.
No, we are not, Milord, we are very much keen to place it in the house rather. ATR is to be placed before the house. That is the mechanism under the Commission of Inquiry Act.
Yes.
So, Milord, there is no dispute. Your Lordship may pass any order.
Yes.
So, number 2, this inventorization, both these things.
No, we
Milord,
will also ensure that once the SOP has been approved by the Sri Jagannath Management Committee and also the Gajpati Maharaj, then you'll have to take a call and then say whether you accept or not accept, or you wanted some modification, everything, a decision has to be taken.
No, that's correct, Milord.
So we will
That
direct
has
you
come
to take that decision.
17th of January, that has come only a week ago. So,
No, I understand.
the
So
government is
we will take a
examining.
decision and we'll also fix if the decision is taken. Yes. Yes. We'll pass the order. 30th.
Item number 30.
Sorry, my lord, item 27, the connecting numbers
Yes,
just passed.
I have got it. Item number 30.
Yes.
And for the opposite parties number 4 and 5, we have filed our counters. And for the opposite party number 4 and 5, we have already filed our counter.
Yes.
This is been filed by the state, my lord. Opposite party number.
Who is for the petitioner? Mr. Bhojrat Seth. Anybody know? Huh? Is a regular practice? Yes. Where?
Was that shit? But it should have nothing done. He goes to his village and gathers vines.
What to do? Another case I suppose of this, before the other cases, that it will appear after 6 weeks.
Item 31.
Initial development, 30 minutes. Counter and agenda is already filed. 30 minutes may be taken out some other day for final hearing. But I'm so sure I am unable to. I've taken consent of my.
Next week.
Item 32.
Item number 32, nothing for the OP number 6 needs time to file counter. The usage will be more. The usage will be more.
Here's the first extension.
Yes, sir. After receiving the notice,
First extension.
yes, sir.
3 weeks.
Yes. You will also be kindly see it's a land which is made for Magha Saptami and all. Magha Saptami is today.
Yes, 3 weeks. It's not that only.
3 weeks will be more.
No, more.
No, 3 weeks will be. You'll also be definite. But next week or what?
In 21 days.
3 weeks to 21 days. Or you also may say 14 days.
3 weeks. 3 weeks.
Item 33.
The date may be linked to that, madam.
17. 33. Item 34.
Lord,
Look at the plan. Why don't you serve well in advance?
I filed it today.
The company is writing for.
This letter relates to the strike by government.
What do you have?
Strikes for a mass leave that was called by the US officers. So also the.
What happened? Have they?
That period is over. That period of mass leave has been treated as leave. by the authority.
Now, the strike has.
Yes, it's long back. But strike has gone long back. PIL filed thereafter that no departmental action or disciplinary actions have not been taken against these.
Yes. So what we have done? Immediate action be taken to keep the period as absent. And be adjusted on a leave due to each of them.
That was not treated as a strike, but as a mass leave, and that was not a strike.
That is in section 8, mass leave includes strike. It's given in section 8 minutes. I quoted that at page 12. Next position is page 13.
You wanted a first extension. I find the affidavit was directed on 23/12. You have asked for a time to file. So far as you have asked for 8 weeks time. Why?
Not 8 weeks.
You have said?
It is there within their instruction, actually 2 weeks time.
2 weeks, sir. They joined the 1 week. 3 weeks. So which?
Item 36.
May I please, Manoj? Manoj, this matter relates to that SI examination and CBI investigation, Manoj.
Manoj, already been entrusted.
No, I'm not there, Manoj. Manoj, the subsequent, Manoj, kindly have a glance to your lordship's last order, Manoj. It's 22nd December 2025, Manoj.
That is the only order.
Yes, Manoj. They have to file its counter, Manoj. Letter.
Have you?
But in the meantime, I have received these instructions.
What?
And now the state government has framed a route with respect to uniform service commission. They have established a uniform service commission which will conduct the recruitment.
By their own.
Yes, Manoj, by their own.
That's good.
That is only after your lordship's kind intervention, my lord. I have
enclosed that gadget.
Yes,
but it is not page number.
Here it is.
Number 4.
Is at the last. Towards last. The gadget is there. The gadget date is 5th December 2025.
Only after your lordship's kind intervention. And my lord pleases to know what is the statutory force of the SOP, my lord. Now they are in rules. My lord, but my lord, one thing, my lord, then what is the process, how they will proceed, my lord, that is my lord. Let them file it through counter.
You can't, because they have.
No, my lord.
So once you have constituted a
commission.
So it's the commission who will take care of it.
Yes, my lord. Yes, my lord. Commissioner to be appointed, members, so many things are there, my lord. Let them at least file their counter, my lord.
No.
Because my lord, in the paragraph number.
Where you have included?
But that gadget.
Gadget here, my lord. Here are the gadgets.
That is already there. It will not see my
Data copy. December 2025.
5th December 2020. That gadget is.
No, that is here. Oh, it is here. Oh, they have done it. The mechanism has been done. So have you set up the entire where you appointed all the persons?
Let them file that one. Let them out. Because it is rule regulation to be framed, so many things, my lord. Because here, my lord, your lordship's order dated 2.1 is. That is Orissa Uniform Services. Staff Selection Commission rules.
Have you seen that?
Yes, I'm only, that's what I'm saying, my lord.
Constitution.
But how far they have proceeded, my lord?
Staff selection commission. But in the state.
So now this constitution has been under section.
Chairman and 2 members to be appointed by the government. What about you?
I'm not disputing that, my lord. I am but, my lord. This has been, rule has been framed. But
It's not been implemented. Understand?
order,
No, rule 3, notification has not come.
that's what my word, my lord.
The chairman.
Let them file it through appeal, what they are doing, my lord.
The members.
Pardon, my lord, pardon.
That he has not. No, it's
One
not.
commissioner, 2 members, my lord.
Oh, how you will make it?
Rule has been framed only on 5th December 2025. It takes time to establish that.
Tell me how long you will take it, because nowadays we have to put a.
Because I am here because, my lord, it's about law enforcement agency, police, my lord. That's why, my lord, I am pressing, my lord. Otherwise, a huge number of vacancies are there.
Regarding that time frame, I'll file an affidavit specifically for this Honorable Court, let the authorities file that affidavit, because the instruction doesn't disclose.
The extension by what? By 2 weeks? After 2 weeks. Probably a copy in advance.
What?
Deeply obliged, my lord.
37.
My lord, item 37, I'm appearing through VC for the petitioner. My lord, as per your lordship's last order of 6th of January 2026, my lord, I have been served with a copy of the counter from the state, opposite parties number 2, 3, 4, 5, 6, 2, 3, 4, 6, and 8.
Yes.
And the opposite party number 10 have already filed their response, my lord. My lord, I will be filing my rejoinder affidavit within a period of 2 weeks, my lord.
Need to file our response as per your lordship's order dated.
What, within what time?
My lord, 2 weeks, your lordship, 2, 3 weeks.
Wait.
Any.
For rejoinder. Pension of.
38.
Take your lordship, there was a notice to the other side. They have to file the reply. Little embarrassment, my lord. Somehow the inspecting council is not there. But you are.
Where he has gone?
Notice. I think some insufficient address. Mr. Insufficient address, option number 6. There is a notice to the other side. They have to file the nothing is that. Undelivered notice returned from office 6. Insufficient address. My lordship will find only office 6, my lord, insufficient address. 3 and 4 it is delivered. 2 and 3 is 3 and 4 it is delivered. It can be on
2 and 3.
2 and 3 also delivered. My lord. 2 and 4 is over. My lord.
Yes, what do you want?
6 to. I think this is non-existing now. 6 is changed. Management is changed. I think name of the college and hospital is also changed.
Is no longer high-tech medical college and hospital.
No. It has been taken over by some other trust. I'll just find out the cost, I think. Okay, number 6. Yes. You are aware that about this. I think name is also changed.
I'll find out, I'll take fresh notice.
Bhubaneswar.
Madam,
Ah,
we'll take fresh notice on
no,
it.
it has to be taken over by some other foundation or.
I'll just find out, I'll take fresh notice on 6th month.
I take medical
I
college.
take that somehow, I think it is still in existence.
Pandora. Still with Panigrai. So full.
It forms a part of the central civil.
I have challenged that one.
Where is the virus you have challenged?
Yes, I have challenged that one.
This is you have simply said the court has set aside the levy of.
Levy of additional fees.
That is on you. I will challenge that this is unconstitutional. This is this cannot come. You have not challenged it.
I have challenged, but
Mr. Fani, how come you say that it is penalty?
because my lord, that is one
Sir, fee is something different from
my lord,
penalty, fee is different from tax.
my lord. But here
Sir,
I
here-
failed to pay the tax, my lord. I didn't fail to pay the fees.
Sir, in the word an additional fee.
Yes.
So your prayer is prayer, penalty.
I say it is can be treated as a penalty because once this what is the tax is there, but it's automatically it is not.
So the penalty cannot coexist with the tax.
So penalty will coexist, but that is the domain of the state government. That I pray, my lord. That I your lordship will go to.
This is not a late fee charges. Is it not a late fee charges? Can they not levy a late fee charges?
But the Union of India has no power to do it, my lord.
Why not?
Because
Union of India has a power. Has
to
a power to frame the central motor vehicles rules.
my lord.
Can we not incorporate any kind of a?
Because so far the tax is a concern that is.
Why you are, it is not a late, it is really a late fee. It is not a penalty. It says that so long you do not pay, you will be charged with this.
But my lord,
Are you not, even in the income tax also, if the return is not filed within a particular time, late fee is not charged to accept the return.
But due to non-payment of tax, they are charging this.
That is the.
It is not a late fee.
It's you have to pay within certain time. If you do not pay, you are still permitted to pay. You can pay, but there will be a late fee which will be imposed upon. You have to pay the late fee.
Already, there is a judgment of Kerala High Court. There is a single bench judgment that has already locked down the tax.
Sir, I am conscious of a difference between tax fee and levy and assess.
My lord.
These are the four different incidences. The tax can be imposed by virtue of an powers conferred under entry
60
under 7th schedule, the entry
Entry
1 by the state, by the union, and entry 3 by the state.
Your lordship, entry 57. Entry 57
Of
list two.
first list, state list, or central list.
Central government can levy, I fix the principle of tax, but levy of tax they cannot do it. That will be levied
Show me
under
the
entry.
7th schedule.
Yes, my lord.
List
Entry
1.
57.
List 1.
Yes, list one that is 35 your lordship.
Yes.
List one. This is following up list three matters. Concurrent list, you will also go through the concurrent list three. List three was 35 million. That is mechanically propelled vehicle, including the principles on which taxes on such vehicle are to be levied. That is the reason central government can say about the principle of a tax matters. What the list two. That is entry 57. Taxes on vehicles, whether mechanically propelled or not, suitable for use on road, including tram cars, subject to the provision of entry 35 of list 3. So list 3 and list 2 are important. Man. That is list 3, concurrent list entry 35 and list 2 57.
General power of, rule making power.
Rule 64, section 64 of the Motor Vehicle Act. 64, there is only fee. About no tax there.
Just one.
Section 64. That is on the registration. Because this is regarding registration section 63. The central government is empowered. That is, I understand, no tax. Yes. Under Article 246, the state is empowered to levy tax. According to the separate Odisha motor vehicle taxation has been framed by law. There is there, there is separate section is there. Act is there. Every state has the power to levy the motor vehicle tax separately, all throughout the India.
As per the Union of India, my senior is in this. Yes, where is your senior?
Mr. Padi, yes, Mr. Padi.
Yes, my lord.
How can you, he is saying that how can you impose the fee on a tax?
My lord, the government of India has a power.
Yes, where is the power? From which entry?
60, come, let's make see the section 64.
Yes.
The power of the central government to make rules.
True, but does it relate to any additional fee for late payment of the tax?
Yes. The Central Act has enacted
No, he is raising an issue that how can you fix a additional fee for delayed payment of tax?
that is a separate gazettation made. I can produce my law. Let's make
So
give some
that
time.
power, he says the power to impose tax is there.
After 64 and 65 should take conjointly. 64 and 65 should take conjointly, my lord. The power of the state government to make rules. It should take conjointly.
Relating to what? Tell us.
This additional is concerned what my lord
Mr.
said.
Pari, it is not the state.
Central government.
Central government has brought out the rule by way of rules
my lord,
with regard to BH series of vehicles. When tax is not paid within 2 years from the due date, from within 7 days from the due date in each 2 years,
yes,
then additional fee of 100 rupees per day you are charging.
Yes.
So under which provision you derive that power to levy additional fee?
That gazette information we have, I will produce the my lord, because what I remember, Lordship also sitting with the another coordinate bench, Lordship may remember that case. The same question will put my lord, and we are submitting a notification basing on which these two high courts has passed the order against us. The two high courts have passed in our favor. So Lordship, give some time. I will make it research and produce before the my lord.
Sir, I think we are reminded of settled law or principle laid down by Supreme Court.
Yes.
That we have distinct connotations so far as tax, fee, and penalty are concerned.
Yes, correct.
Levy, cess, different.
Cess is different.
Yes.
Levy is also different from collection.
What?
To pay the tax, I want to pay the tax. I need
Do it. To show your bona fide, pay the entire amount which they have claimed.
heavy amount.
We will adjust it. Don't worry. If it's struck down, we will,
They are asking to pay.
suppose if you lose, then
I will not lose my. Because
why? You are so, are you there that what the judgment is to be written?
I sorry, madam.
So,
But there is a.
So,
Allowed at least.
there may be a probability. You may succeed, you may not succeed. So in order to keep a balance, you pay off the money and that will be adjusted.
Penalty will be 200%. I will pay the, as per the state government. Penalty will be 200.
There is no penalty, sir, in this. It is only additional fee.
So let me.
Why are you mixing that connotation,
Oh,
penalty and
so he's a-
additional fee?
Pay the entire demanded amount. There is no, without prejudice to your rights and contentions. Raised. We can grant you otherwise.
Some amount to relax, take 50% or some amount. I will.
No, sir. No, sir.
Then you lots will pass that out.
Yes.
And I will be allowed to amend my application. Just I will pay a portion.
So, the
21. That is relating to an election matter where my election has been declared void. May I
Void.
come tomorrow,
So
maybe.
you are,
I'm the return candidate, madam. I'm the return candidate. Now I have been, the honorable single judge has been pleased to confirm that order. I had made a mention, I am praying for tomorrow at least maybe taken up at any convenient